On the morning of March 23, 2010, a cyclist in Marin County, California, descended a familiar road at full speed. He was chasing time, not a race time, not a competition time, a Strava segment time, a number on a leaderboard that existed only on his phone. At the bottom of the descent, he struck a pedestrian. The pedestrian died at the scene. The cyclist was charged with felony manslaughter. And then the victim's family sued Strava. Not the cyclist. Strava. To understand why that lawsuit was possible, you have to understand what Strava actually is. Not what it calls itself, what it actually is. Strava calls itself a fitness tracking platform. But fitness tracking is not what makes people open it every morning. What makes people open it is the leaderboard. Every road, every hill, every descent that enough people have ridden becomes a segment. And every segment has a king of the mountain. A KOM, the fastest recorded time, the number to beat. Strava did not invent competitive cycling, but it did something arguably more powerful than inventing it. It installed a competition on every road that cyclists already used, without asking the road what it thought about that. The cyclist's name was William Flint. The pedestrian he struck was Kristy Gough, a triathlete and nurse. She died on impact at the bottom of Diablo Boulevard in San Anselmo, California. William Flint was descending at a speed later estimated between 40 and 50 miles per hour. The road had a posted speed limit of 25. He was chasing the KOM on a Strava segment called the Diablo Boulevard descent. Flint was convicted of felony manslaughter in 2012. He was sentenced to 3 months in jail and 3 years of probation. But the civil case, the lawsuit against Strava, was still coming. The lawsuit filed by the victim's family made a specific argument. Strava had designed a product whose primary feature was incentivizing users to go as fast as possible. On public roads, among pedestrians, without any safety warnings. The argument was not that Strava caused the crash directly. The argument was that Strava created and promoted a system that it knew, or should have known, would cause people to take dangerous risks on public roads. This is a question that had never been properly tested in court before. Can a platform be liable for the behavior its design encourages? Is a leaderboard legally responsible for what people do to reach the top of it? In 2014, a California Superior Court judge dismissed the case against Strava. The ruling, Strava did not owe a duty of care to the pedestrian who was killed. Because Strava was not present at the road. Strava was an app. The legal question was resolved, but the moral question was not. In the decades since, it has only gotten larger. Strava now has more than 120 million registered users. There are over 80 million segments on the platform globally. Every single one of those segments exists on a road that was not designed for racing. Since the 2010 crash, there have been multiple fatalities linked to Strava segment attempts. In the UK, in Australia, in the United States. Each time, the legal outcome has been similar. The platform is not liable. In 2013, a British cyclist died on a descent in North Yorkshire. While attempting to break the KOM record on a segment called the Thirsk to Sowerby Road. He was 50 years old, He had been using Strava for 6 months. The coroner's inquest found that the Strava segment had contributed to his decision to descend at speed. The UK coroner called on Strava to add safety warnings to dangerous segments. Strava declined to comment on the specific recommendation. Here is the part that the legal framework cannot reach. Strava knows exactly which segments have the highest average speeds. It knows which segments are on roads with speed limits, pedestrian crossings, blind corners. It has this data because it collected it from the people who were injured or killed chasing those times. That data exists inside Strava's servers right now. It has never been made public. In 2014, under pressure following multiple deaths, Strava introduced a feature called segment hazard warnings. It allowed segment creators to flag their own segments as potentially dangerous. The feature was voluntary. It was opt-in, and it placed the responsibility for flagging dangerous segments on the users who created them. There's a version of this story where Strava is simply a tool, a map, a stopwatch, a way to share your rides with friends. And tools are not responsible for how people use them. But there is another version of this story, where Strava is not a tool that happens to have a leaderboard, but a competition that happens to have a fitness tracking feature. The difference between those two versions matters enormously, because the first version has no obligation to think about what happens at the bottom of a descent. The second version does. Strava has never acknowledged the design of its platform as a contributing factor to any death. Every case has been settled, dismissed, or ruled in Strava's favor. The legal question appears to be closed. The other question, whether a platform is morally responsible for the behavior its design creates, is still very much open. And it is a question that reaches far beyond cycling. Until the next investigation, keep the files open. File closed. Next file. A race from 1904. A winner that changed 4 times. And cheating methods so creative they weren't even illegal yet. The bike files. Subscribe for the next case.